This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Ms. Lindsay. And on behalf of Judge Bennett and Judge McBrayer, we are pleased to welcome counsel to this oral argument, which is being live streamed so that we may fulfill our obligation to maintain open courts. We have 4 attorneys participating in this Zoom hearing, but only 2 of you will be arguing, one for the appellant and one for the appellee. Each of you has 15 minutes to argue, and the appellant has reserved some of the 15 minutes for rebuttal. Thus, unless there are any announcements, I will ask Ms. Lindsay to call the case.
James Keith Eudaley versus U.S. National Bank Association.
All right, you may proceed.
Thank you, Your Honors. Good morning. May it please the court. My name is Tiffany Ray. I'm with Taylor Martino, and I represent the appellant in this case, James Keith Eudaley. This case, there's a single issue before the court this morning, and that is, did the trial court err in granting a motion to dismiss to the appellee, U.S. Bank, on grounds of federal preemption of national banking laws? We argue that it did. This case, at its heart, is about U.S. Bank passing along the cost of the recordation fee charged by the county office for releasing the deed of trust on a loan to the consumer in violation of Tennessee law. Mr. Eudaley obtained a mortgage loan for $98,000 on a home in White Bluff, Tennessee from U.S. Bank in 2015. As part of that process, U.S. Bank recorded a deed of trust with the Dickson County Register to secure the loan. Mr. Eudaley repaid the loan in full in 2019, meeting his obligations with U.S. Bank. At the conclusion of their arrangement, U.S. Bank then recorded a release of the lien with the Dickson County Register. As part of that process, the county administrative office charges a $12 fee. U.S. Bank then charged Mr. Eudaley that $12 fee to recoup that cost. That action violated Tennessee Statute 6625-115. The statute specifically states that all costs of making entry or partial or entire payments upon the record, or for registering a formal release, as in this case, shall be paid by the holder of the debt secured by the mortgage, deed, or other lien. The statute is very clear and it's very simple, and U.S. Bank, in violation of this statute, passed on the cost to Mr. Eudaley. Mr. Eudaley therefore brought suit on behalf of himself and others similarly situated, this is a putative class action lawsuit, to recover the $12 recording fee. Mr. Eudaley brought 2 causes of action: unjust enrichment and negligence per se. U.S. Bank brought a motion to dismiss in the trial court, raising 4 grounds for dismissal. The trial court addressed only 2 in its memorandum opinion. The first issue was statutory interpretation. U.S. Bank contended that the statute didn't say what it said, that it merely required them to record the release of the lien, and the trial court correctly determined that it did not, that it in fact was a prohibition on passing that cost on to the debtor. However, the trial court addressed the second issue of federal preemption and determined that U.S. Bank and other national banks were exempt from the statute under federal banking preemption principles, And that is the issue that we bring before you today. We contend that the trial court erred in that determination in a couple of key respects.
Well, part of your argument here, as I understand it, is that you have to distinguish between charges, non-interest charges and fees under the OCC regulations and a pass-through. Do I understand that correctly?
A little. It's a little bit more, it's a little different from that. Essentially, the distinction that we are making is that the case law used by US Bank to support this position, it talks about preemption where banks charge fees for their services. And the federal regulations do give banks the power to charge fees for their services.
So in this circumstance like this, it would have been okay for US Bank to say, we're charging we have to go to the trouble of walking to the registrar's office or driving the registrar. We're going to charge a release fee for that. And let's say we'll make it $12. That would be okay?
I'm sorry, Your Honor. I don't think I quite heard the rationale for the charge.
So let's say, just as a matter of, we have to go to the trouble due to the statute to record a release, we're going to charge a fee for that. I mean, the bank has to have someone go to the registrar's office and record the release, and say they wanted to charge a fee for that, they could do that, and say they selected $12. That would be permissible under the statute?
If they provided a service that they valued at $12 under the formula set out in the Code of Federal Regulations, then they would be free to do so. This specific fee is prohibited, however. And we also argue it is simply not a service that the bank is providing. It is a service provided to the bank by the county to securitize its loan. It is a protection for the bank. In fact, this court has said so itself. It says a lender records a deed of trust for its own benefit. If it's recording it,
well, they record a deed of trust for its own benefit, but the release they're recording is to avoid criminal penalties, aren't they?
There are penalties attached in the same statutory scheme for not releasing the lien. That is correct.
So it's really the bank's incentive, as soon as they recognize a payoff or have received the payoff, to get to the registrar's office as soon as possible, because there's a clock running that if they don't get that release recorded, they're going to face possibly civil and criminal penalties.
But it's only an incentive for them because state law says so. And that is exactly our point here. The state law, as part of the statutory scheme that includes 6625-115, requires banks and anybody, not just banks. It's a generally applicable law. It requires anybody holding a lien, a deed of trust, some security to record that lien with the registrar's office, and then to release that lien, and not releasing that lien incurs fines and potentially legal action. It also, and the fact that it's part of this larger statutory scheme, I think also reinforces the fact that it's not preempted by federal law, because these other provisions are not preempted. Why just this one? They are required to record the lien, to release the lien. They do incur fines if they don't, but somehow not recouping the recordation fee charged by the county is the only part of it that is preempted. Another fact that I think supports this argument is that this statute isn't unique. There's at least one other state, West Virginia, that totally prohibits recouping this cost from debtors as well. And many other states have statutes that limit the bank's ability to do so by either stating that they can charge only a reasonable fee or by setting a cap on the fee. One state, I believe, sets a cap on a collection of administrative fees in connection with a loan. They take different forms, but they're not unique at all. And if those statutes aren't implicated by federal banking principles, then neither is this one. I would also note that the trial court, in its rationale, relied on conflict preemption, which is a rather specific form of federal preemption, and it requires that the statutes be an irreconcilable conflict. There is no federal statute that is an irreconcilable conflict with a pass-through an anti-pass-through provision set out by the Tennessee legislature. In fact, the case law set out by the Supreme Court states, in terms of conflict preemption, that compliance with both statutes, for example, may be a physical impossibility, or the state law may stand as an obstacle to the accomplishment of an execution of the full purpose and objective of Congress. That's from Barnett Bank of Marion City versus Nelson. And that simply isn't the case here. The statutes relied upon by U.S. Bank and by extension, the trial court simply don't irreconcilably conflict. 12 USA 24 simply grants banks the power to exercise all such incidental powers as may be necessary to carry on the business of banking, and it includes loaning money on personal security. That has not been deterred by the statute clearly, which is evidenced by the fact that U.S. Bank did in fact make a loan to Mr. Eudaley, and it was repaid in full. 12 U.S.C. 371, which is also relied on by the trial court, same things. It grants the banks the power to make, arrange, purchase, or sell loans or extensions of credit secured by liens on interests in real estate. Again, that's exactly what happened here. So obviously that statute has not been implicated in any way. The third one and final provision relied upon by the trial court was 12 CFR 7.4002 from the Code of Federal Regulations, which essentially grants banks the power to charge fees for their services. And that goes back to the argument I was making earlier in our discussion that this is not implicated because it's simply not a service that the bank provides. It is a bank provided to this service. It is a benefit, and it is not just for banks. It is for anybody that wants to record an encumbrance.
All right.
Thank you.
Thank you, Ms. Ray, for your argument. We'll now hear from the appellee.
Good morning, Your Honors, and may it please the court. My name is Tom Cunningham, and I have the honor of representing U.S. Bank National Association in this appeal. As appellant's counsel has indicated, this case presents the issue of whether a national bank can charge its customer a fee or a charge related to the recordation of a release of a mortgage or deed of trust. The issues in the applicable law are set forth well in the briefs submitted by both parties, but I'd like to highlight two issues in my presentation this morning. First, I'll address federal preemption, as that was the basis for the trial court's decision to dismiss the plaintiff complaint. And it's also been the focus of most of appellant's argument in this appeal. So I'll address that first. And then second, time permitting, I'll address one of our alternative arguments that even if federal law permitting the bank to charge fees does not preempt a conflicting Tennessee statute that prohibits a fee, there is still no private right of action that the appellant in this case can rely upon to seek recoupment of that fee. The complaint in this case purports to allege causes of action based on negligence per se and unjust enrichment, neither of which really fits the facts or issues in this case. But let me first begin by addressing federal preemption. National banks are primarily governed by federal law, as you know, including the National Bank Act and implementing federal regulations. National banks are subject to state laws, but only to the extent those laws do not conflict with federal law and the authorities and powers that are granted to a national bank by Congress. Federal law plainly authorizes national banks to, quote, establish non-interest charges and fees. The statute and the regulation are not very specific about what fees and charges a national bank is authorized to charge. That's committed to the sound discretion of the bank in terms of profitability and maintaining the safety and soundness of the banking institution. If Tennessee law prohibits the bank from charging its customer a particular fee, as appellants argue, that would plainly conflict with federal law that allows the bank to determine what fees and charges it should charge its customers. Numerous courts around the country, considering state restrictions on the fees that mortgage lenders can charge their clients, have concluded that when those restrictions conflict with the general federal law permitting national banks to determine what fees to charge, the state laws must give way. I'd like to also remind the court that the general presumption against federal preemption does not apply when considering issues of preemption in the context of national banks and the National Bank Act. Typically, there's a presumption against federal preemption, but that does not exist in the case of a case like this. The U.S. Supreme Court has held that the standard this court should apply in determining whether a state statute interferes with a national bank's ability to charge a fee is not very high. In its 1996 decision of Barnett Bank of Marion County versus Nelson, the Supreme Court said that powers granted to national banks will not normally be limited by a state statute, and ordinarily the federal power will preempt contrary state law. And there's a 2009 Sixth Circuit opinion in which the court said the level of interference that gives rise to preemption under the NBA or the National Bank Act is, quote, not very high, unquote. This is the lens through which this court should review the conflict between the power granted to national banks under the National Bank Act and federal regulations for national banks to establish fees and Section 6625(115)'s purported prohibition of charging a customer a fee to record a release of a mortgage.
Where do I go in the regulations to find authority for a national bank to pass through fees?
So Section 7.4002B2 of Chapter 12 of the Code of Federal Regulations addresses the bank's right to charge fees, non-interest charges and fees. And the interesting issue, which Your Honor picked up on and asked my appellant's counsel about, is whether the charge in this case, the $12 charge, was in fact a pass-through. It is a fact that the bank paid the Davidson County Register $12 to record a release of the mortgage. But it's not necessarily true that the $12 is a fee that the bank is charging the customer for a service rendered, or if it's simply a charge the bank is making to offset the cost that it incurred. If you think about it, what is the difference really conceptually between charging a fee for a service the bank provides or offsetting a cost the bank has incurred? Conceptually, it's the same thing. You're reducing the adverse impact on the bank's profitability. The bank is selling a product. That product is a mortgage loan, and a mortgage loan conceptually is nothing more than a bundle of rights and obligations of the parties to that loan. One of those rights and obligations, as expressly set forth in the deed of trust at issue in this case, is the ability of the bank to charge the customer for a cost that it incurs in handling the customer's loan, in this case, the recordation of the fee. So it's not clear to me that this is necessarily a fee versus a charge. I think it may be considered a charge. It could also be considered a fee. As Your Honor correctly pointed out, one way to look at this is the bank is in fact performing a service for the benefit of the borrower. It must have systems and operations in place, procedures to record releases of mortgages and deeds of trust when loans are paid off. It has to employ people to operate those systems and procedures, and it has to pay fees to county recorders when it records those releases of mortgage. It's entirely within the bank's power to offset all of those costs and charges in offering this product to its customers by obligating the borrower to pay the bank a fee or a charge. And I agree with you, Your Honor, that this could have been a $15 charge, could have been a $20 charge, could have been a $25 charge. And indeed, if the bank is told that it is not permitted to charge $12 in Tennessee because of the Tennessee statute, then perhaps it ought to be charging $15 or $20 and saying, well, this is a service that we render for the borrower. And let me be clear, the recordation of a release of a mortgage is for the benefit of the borrower. It is not for the benefit of the bank. It is to comply with state law. But frankly, the bank would record a release of its lien regardless of whether state law required it to or not. Appellant's counsel raises the question of, well, if the prohibition on passing through this charge is preempted, why isn't the rest of the statute? Well, the answer to that is very simple. It doesn't conflict with anything in federal law. There's nothing in federal law that says a national bank doesn't have to record a release of lien at the end of at the payoff of the mortgage. And because there's no conflict, that is a good example of a state statute that the bank is obligated to follow because it doesn't conflict with anything in the federal law. The argument that the fee or charge must relate to a service provided to the borrower, even if it isn't a service provided for the benefit of the borrower, and I argue that that's one way of looking at it. There's no authorities that say that. In fact, there are at least two cases that have said exactly the opposite. Both of those cases concluded that a national bank is not limited to charging fees for services that it renders to a borrower. The first of those cases is called Mcgee versus Bank of America. It's found in 2015 Westlaw 4594582. It's a Southern District of Florida decision from 2015 that was affirmed by the 11th Circuit. And in that case, the charge that was involved was an extended overdrawn balance charge. It was essentially a fee for overdrawing the customer's account, not for any service that had been rendered to the borrower. And the plaintiff in that case argued that this charge, because it wasn't for a service that had been rendered to him, had to be considered interest under the NBA. And if it were considered interest, it would violate the limits placed on the interest rates that national banks can charge. The bank argued that these charges were fees under the NBA and under Code of Federal Regulations 7.4001. The plaintiff argued, as Mr. Eudaley does in this case, that it could not be a fee under those statutes or a charge unless the bank were rendering some service to him. The court agreed with the bank in that case that these were charges or fees under the NBA and its implementing regulations, even though they did not involve the provision of any service to the borrower. The second case is a case called Walker versus Bokf. It's a 2019 decision from a district court in New Mexico. It's found at 2019 Westlaw 3082496. And it presents the same issue as the Mcgee case. It also involved extended overdraft fees. Again, the plaintiff argued that this must be interest, it can't be a fee because it doesn't involve the provision of any service to the borrower. And again, this court agreed with the court in Mcgee, rejecting that argument, saying, quote, that a charge is based upon something other than services does not necessarily remove it from the category of non-interest charges, unquote. So the federal law is general. It says the bank can charge fees and charges. It doesn't say they have to relate to any service. It doesn't prohibit passing through a cost that the bank has incurred as a fee or a charge. And if the Tennessee statute is interpreted in the way the appellant urges, and in fact, the way the trial court determined was correct, and that statute prohibits the bank from making that charge or charging that fee, then there is no question that the two conflict and state law must give way.
Counsel, I noticed you didn't touch on Monroe Retail against RBS Citizens. Was that case correctly decided?
Yes, Your Honor. I believe Monroe Retail was correctly decided. Monroe Retail is important for its establishment of the standard of conflict between a federal statute and a state statute as not being a very high bar to cross.
Although Judge Cole certainly had a different opinion about that in its dissent, it strikes me that Monroe Retail makes some broad statements about preemption that I don't know is supported by the case law cited in that opinion, in the majority opinion.
I can appreciate that position, Your Honor, and there was a dissent in that case. Just as a reminder for the court, this was a case involving a $25 to $80 service fee related to garnishments when the bank is served with a notice of garnishment. The Ohio statute in that case limited that fee to $1. And there was obviously a conflict between the Ohio statute and the general notion in the National Banking Act and the Code of Federal Regulations that a bank may charge fees and costs. The issue really in Monroe Retail was, what does the word significantly, or what do the words significantly impair mean? In that case, and the majority opinion basically said not much. Even if you look at the dissent in that case and you look favorably upon the dissent, I don't think the dissent goes so far as to say that where there is an unquestionable conflict between a state statute and a federal statute, as there would be here, if the statute is interpreted as the trial court and appellants counsel have urged, that the state law is not preempted. There is no question, I think, that there is a significant impairment of the bank's ability to charge fees if the state statute says you can't charge a particular fee. I have only a minute and a half left of my time, but I'd like to briefly touch on my alternative argument and basis for affirming the trial court's decision. First of all, I'll remind the court that generally Tennessee appellate courts may affirm judgments on grounds different from those relied upon in the trial court, so long as the lower court's decision was correct. And there are two cases: Basley versus Rain Incorporated at 29 Southwest 3rd, 879. And White versus Johnson, 522 Southwest 3rd at 417, both of which say that an appellate court can affirm a judgment on alternative grounds from those found by the trial court, so long as they come to the correct result. Here, there is no basis to allege negligence per se. The statute in question does not establish any standard of conduct that would provide for a duty on the part of the bank that it would then be negligent for the bank to violate. And there's also no unjust enrichment. Certainly, charging a fee for recording a release of mortgage can't be said to be unjust. And secondly, the bank isn't enriched if it pays the county $12 and it charges Mr. Eudaley $12. It's neither unjust nor an enrichment. And for that reason, those two causes of action simply do not fit. Thank you very much for giving me the opportunity to address the court this morning. I'll conclude my argument here.
Thank you, Mr. Cunningham. We'll hear a rebuttal from Ms. Ray.
Thank you, Your Honors. I'd like to touch a little bit on the cases cited by counsel for the appellee involving the overdraft charges. And that dovetails a little bit with your discussion on Monroe detail and the garnishment issue. These aren't parallel to the charge by the Dixon County Register for recording the fee. Yes, they're not fees for a service perhaps provided by the bank in terms of what the customer is there for, but it is a fee charged for stepping beyond that agreement with the bank. It's a fine essentially, but it's specifically related to the account serviced by the bank. It is a very traditional role of the bank to hold money for people in accounts and to service those accounts. And so having a charge related to that fits squarely within the other cases cited by the trial court and by counsel that have to do squarely with banking services. Same with the Monroe Retail as well. It's specifically related to servicing bank accounts. It's perhaps not a welcome service, but it is a service nonetheless related to a very traditional banking, something that's in the bank's wheelhouse. It is not in a bank's wheelhouse to record liens or to record the release of those liens. So this is a materially different thing.
But it is in the bank's wheelhouse to lend secured by realty, though.
Yes, and again, the security is for the bank's benefit. That's a service provided by the bank to ensure that they get paid back. Lending the money is a service provided by the bank, and they do charge fees for that. They charge preparation fees, origination fees, all kinds of fees. I don't think banks are short on fees, but the service of recording the lien is specifically for their benefit, and I don't think there's really any common sense way around that. I would also like to address, there was some discussion in what I think counsel was saying is that the charge is an offset for costs incurred, and therefore the bank could just call it something else and charge an extra $12 someplace to make up for it in another way. So it's 6 of one, half dozen of the other, I guess. That's if I'm understanding that argument correctly. And I would just like to say that doesn't negate the violation of the statute. I think there are lots of examples of people getting around rules. I think the size of the tax code is perhaps an example of that. So while that's perhaps true, I don't think that is a cogent argument.
Well, I guess your point is that's not this case, because it's fairly clear that the fee charged matched up with recordation fee for recording the release.
Yes, in this case, it's not an issue anyway. It's kind of a theoretical point just relating to the issue overall. But I wanted to just quickly address that. With my last 20 seconds, I would just say as to the other issues, they were not addressed by the trial court. And yes, this court has discretion to address them if you wish. I would suggest that they are more appropriately addressed in the first instance with the trial court. And I would stand on the briefs on those issues. Thank you.
Thank you, Ms. Ray and Mr. Cunningham, for your arguments. We will take this matter under advisement. Ms. Lindsay.
This Honorable Court of Appeals of Tennessee is in recess until 1 p.m.
Thank you. And counsel, you are free to exit the Zoom meeting.